People versus Radandt.
Maybe the second time will be fine.
Good morning, and may it please the Court. Eric Misterovich, on behalf of Defendant Appellant Mr. Michael Radandt, I'd like to request 5 minutes for rebuttal. We are asking the Court to reverse the Court of Appeals and the trial court and hold that the officers in this case unlawfully expanded a knock-and-talk procedure, violated the Fourth Amendment by approaching the door that a visitor would most likely approach, knocking, not receiving an answer, and then walking into the defendant's curtilage, being the backyard, the rear deck, and the rear door area. Second, we'd ask this Court hold that the good faith exception to the warrant requirement does not apply because there is no binding precedent that specifically authorized the officer's entry into the curtilage, and because we're talking in this case about officer error. Officer error in conducting the searches, officer's error in completing the affidavit, rather than magistrate errors in the typical Leon-type analysis. Now, before waiving the free fire period, I'd like to provide a little bit more context about the Fourth Amendment rule that we're proposing. The Hardina's Supreme Court case and Michigan Court of Appeals cases from the 2000s, I recognize this idea of an implied license for the public to approach a home. We expect uninvited visitors to come to our house. We expect them to come to the door. And because the public can freely approach our homes, well, of course, the police can too. But this area in which they can approach is limited, and it's limited to a specific area, not only for the general public, but it's even more concerning when it's the police. And it is our position that when officers are engaged in a knock and talk, they must only approach the door an uninvited visitor would approach. They are to knock, and absent an invitation to stay, leave. And when the officers are given freedom to meander about the property and enter into the curtilage, they are unlawfully expanding a knock and talk and violating Fourth Amendment rights. Limitations on a knock and talk in this manner are required to protect the Fourth Amendment's sanctity of the home, but more importantly, the curtilage. If the curtilage is truly the home, officers must be limited to approaching the door a visitor would most likely approach, knocking, absent an invitation to stay longer, they must leave. I'll gladly accept questions from the Court at this time.
What if it's not clear what door a visitor would most likely approach? In other words, not every house, is in a city with a sidewalk that approaches the front door. And in fact, in this case, we're dealing with a house that appears to be in a rural area.
That's right. And the fallback standard, anytime we're dealing with this knock and talk issue, is the ordinary citizen standard. Okay, what would an ordinary citizen do when approaching a home? Now, it's not my position that there is only one correct door to knock on. The analysis would be, is this a door that is most likely to receive a visitor? And in our facts, I think it would be proper for the officers to knock on the front door or what we're calling the middle door. And now, how am I getting to that conclusion? Well, I think the number of factors a court would look at there's such a wide variety of factors that you could look at because we can't predict what every house is going to look like. But in this case, the officers had no problem selecting the door visitors were most likely to approach. They pulled into the driveway, and there was a door right next to the driveway. That's the door they approached twice, the first time. And I would say that is a reasonable thing. An uninvited visitor parking in the driveway would knock on that door. So while the test, there's a lot of room for application to facts, I don't think the test is all that hard in practical application. And as the court in Hardinas noted, this is something that uninvited visitors, salesmen, political canvassers, trick-or-treaters have been doing for decades, longer than that. An ordinary citizen understands where to go to knock on a door.
Do you never get to the back door?
We're not advocating for a bright line rule that you may never enter the backyard, although I do think it's exceedingly rare. I think when an uninvited visitor approaches a home, they are likely to come upon entranceways before they get into a backyard. Now, that's not always the case. If you are, a lot of this will depend on the layout of the home.
But it's not just whether you pass entranceways, it's whether you can determine whether those entranceways are the ones that are going to be most commonly used by visitors or the public.
Yeah, and I think to get to the backyard, to get to a rear door entryway, there's going to need to be some reasons as to why that was the door that was most likely to accept an uninvited visitor. Maybe the front door was broken. Maybe the back door, maybe there's no mailbox at the front door. Maybe the mailbox is by the back door. Maybe the lot is a corner lot and you could see the back door when you're driving by. There's the number of factors that could go into this, the number of homes that this court has to make a rule to address is endless.
What evidence do we rely on to make the determination? There was a evidentiary hearing in this case, and only the officers testified, correct?
That's correct.
So are we relying on their observations? Because I believe there was testimony. The first officer said the middle door appeared to be the entrance most commonly used, but then later indicated that officers thought it was possible that the back door was the entrance most commonly used. And I think another officer testified that there appeared to be more than one main entrance, and notably there was no defense testimony to contradict the officer's testimony. So what evidence should we look to?
So in this case, the evidence that we have to look to is what you just said. We have the officer's testimony. Of course, in other cases, there may be additional testimony. We do have pictures that were submitted as part of motions that could also be reviewed. But in this case, what we're saying is the implied license ended at the middle door. The officers never should have known there was a back door. The idea that the officers think this back door is a primary entrance was only realized once they were back there. And so our position...
How do you know that? I mean, is that in the record? What we have in the record is, so one officer says, what Justice Viviano just said. At one point he says the middle door appeared to be the entrance most commonly used, and then later he says the officers thought it was possible that the back door was the primary door. And another officer testifies there appeared to be more than one main entrance. Do we know when they came to that conclusion?
No, Your Honor, I don't believe the record will give you a clear answer to that question. What I believe the officers' statements are in connection to is this alleged path, that they saw a path to this back door and they think, oh, that's a primary entrance. So this path.
Given the nature of this record, why do you think this case is jurisprudentially significant?
I think it's significant because the United States Supreme Court is sending a message about the protection of the home under the Fourth Amendment in Hardinas, and this is a clear application where there was a physical intrusion into the defendant's property to obtain information.
But the record is kind of swirly, at least as concerning whether this is an entrance you might expect somebody to get to in the normal course. Your client did put no contrary facts in the record about what might be the customary access door. So that leads me to kind of wonder whether this is the kind of case, even if there is a doubt about some issues, why this court should be looking at this case? Because we typically, our rule says jurisprudential significance. So other than there's an arguable constitutional violation here, it's not insignificant. But given the record, why should we be engaged in this case?
Your Honor, the answer is, if curtilage has standing as the home under the Fourth Amendment, this court should hear this case and decide in our favor. The officer,
just because there's a constitutional issue, no matter what the factual record is, if there's a constitutional violation, that is your definition of jurisprudential significance.
I guess in addition to that, the idea of the Hardina's property-based view of the Fourth Amendment rather than the cat's reasonable expectation, I think is a signal from the United States Supreme Court to state Supreme Courts that this is a proper interpretation of the Fourth Amendment. And if I had to guess, I would think that would be one of the reasons why this court chose to accept this case. Now, the idea of this property-based view of the Fourth Amendment and the idea of does the curtilage really equal the home, I think is why this case is so important. It's our position, the officers, they performed under my proposed test perfectly twice without even knowing it. They parked, they went to the door that was right next to the driveway. That wasn't hard for them to determine. They instinctively did it correct. But they said, well, we see signs of life. We see cars in the driveway. We see a dog running loose. I want to talk to these people. I'm going to go look for them. And they entered into the curtilage. They entered into the backyard, turned the corner, and they were at the rear sliding door and the deck. Now, if officers are allowed to expand a knock and talk, to knock, get no answer, and then enter the curtilage, they are entering the home. If the curtilage is the home, they are knocking, not getting an answer, and entering the home. What is the difference between walking through the front door at this point? If the curtilage has any meaning under the Fourth Amendment, you cannot, the Fourth Amendment does not allow officers to just meander about in protected areas.
But counsel, if you could just address the Court of Appeals writings when it dealt with the signage and the fencing issue. How do you feel that plays into this?
The idea that a no trespassing sign is required to have constitutional rights personally strikes me as very strange. In my brief, I cited a case that collected a lot of cases that disagreed with that proposition. It strikes me as extremely odd that the Fourth Amendment rights in my home depend on buying a small plastic sign and hammering it up outside my door. The idea of a fence goes to the question of curtilage, and the Court of Appeals kind of sidestepped this issue and really tried to hold this wasn't curtilage. Okay, fence, was there a fence in this yard? No. If there was a fence, would it make the curtilage determination better in my client's favor? Sure. But we're talking about the rear sliding door of the house. I mean, this is an entranceway to the house. It is the done factors, the proximity factor alone should be enough to find that this is curtilage. I think there's plenty of Sixth Circuit opinions about the backyard being curtilage as well. So I don't think the absence of a sign or the absence of a fence is enough to take this out of curtilage. This is an area of the home that's intimately connected. This is the back door. And so the idea that...
Counsel, what if you have different structures on the property and you know, it's a rural area and you have just different structures? How would you approach that?
So a good example of that is Fro Reap. In Fro Reap, Michigan Court of Appeals case that really addressed knock and talk for the first time, the officers found the defendant in a pole barn. It was a different structure on the property, and there is a determination of, well, is this curtilage? Is this open fields? I mean, that is something that officers need to understand and be able to differentiate in. And so if we're not dealing with a constitutionally protected area, like the curtilage, like the front door in Hardina's, or as I'm arguing, the backyard in Mr. Radandt's case, then we don't have search issues. We don't have Fourth Amendment issues if we're dealing with open field.
What if the backyard's on a lake?
So what would an ordinary citizen do if trying to make contact, an uninvited visitor? Would an uninvited visitor make contact with residents in a backyard when they're on their pontoon boat going by?
The answer is yes.
Here's, I think, an important distinction, and I think the same could be said as, what if an officer walks up and sees someone in the backyard? You know, whether they see him from a boat or they see him from a side street. My answer would be, it's my decision if that person is invited onto my property, not the other person's decision, and certainly not the police's decision. If I see someone, you know, on a pontoon boat and they want to come by and they say, hey, and I wave them over, fine. But if I tell them no, I don't expect them to then keep coming.
What if you're in the house? You can't tell them no because you're in the house.
And they should leave. They should not come. If I'm in the house and I don't hear someone knocking,
Well,
What
they
if
get
you're
off
in the house
the
and you do hear them knocking and you just really don't want to answer?
then
Who comes to your house?
I actually think this matters. Like that, if someone comes to my house, whether they're the police officer
Right.
or my neighbor who comes a lot,
yeah.
and talks for a long time,
Perhaps after today they
Sometimes
won't.
I don't have time to answer the door and deal with that. And I thought the Fourth Amendment said I didn't have to.
You're exactly right. And to go one step further, the last thing you want that person to do is go around and knock on another door. I have small children and a dog. When the doorbell rings, it's pandemonium in my house. The last thing I want...
You're in trouble. That's why I don't have any dogs. And I tell my children to be quiet so I can decide whether I want to answer the door.
The last thing I would expect would be someone to you know, it's our castle, it's our home, but we have a buzzer that anyone can push, and it alerts us, causes pandemonium. I don't want to answer the door. I want that person to go away. The last thing I expect that person to do is walk around to the side door and knock again.
So we can concede everything that you and Justice McCormick are talking about here. I just want to go back to the record. Your position is there's not one magic door at every home.
Correct.
There could be two magic doors.
Yes.
At my house, we live in the country, nobody can tell where they're supposed to come. It's really confusing. Two driveways, we have all these different doors. At my house, I would say there is not one magic door. So, given that there could be two different doors, we have here a record where the only testimony says there appeared to be more than one main entrance, and the officers thought it was possible that the back door was the primary door. So if there could be, the only testimony is, could be door A, could be door B. Is it your position that because they picked A first and B second, it was unconstitutional? What if they had picked B first? That's the only testimony in the record.
An ordinary citizen would not pick the back door first in this case.
How do we know that?
How do I know that? Except because you're telling me that. I got to read this record, and this record said it could be A, it could be B, we weren't sure.
Well, okay, so first, could it be A or B? Again, B is only after they are in the backyard, if B is the back door. Now, how do we know what it's...
So help me with that. If you could tell me that the officer said, oh, once I had already walked to the back door, I realized this might be the primary door. That might be different, but you haven't shown me that in the record.
Well, if you want to talk about missing information in the record about where the officers were, I think a good place to look is the search warrant affidavit.
Okay.
And this gets into, you know, I can come back to why is this a societal norm, but the search warrant affidavit gets to the good faith issue here. And if you look at the search warrant affidavit, the first line says, officers from SCAN went to the above listed address to attempt contact with the subjects at the residence. There were two vehicles in the driveway, but officers could not get an answer at the door. Bingo. That's knock and talk. Anything after that is walking into the backyard. After that is an expansion.
So you say they can only knock on one door. What if they had gone to the testimony in the record says it could be door A, could be door B. I wasn't sure. They picked the back door first. They knocked. Nobody was there. but now they're good. Yes?
My answer would be an ordinary citizen would not go to the back door first.
Oh, but wait a minute, that's not the testimony.
But that's not the testimony in the record. That's what I'm having trouble with. You want to recreate the record.
Well, the testimony in the record is they went to the backyard. We know that, right? And they
Yes.
saw this alleged path, right?
Well, they could see the path, presumably from standing at that side door.
The problem here is, if there isn't one magic door, and the testimony, as Justice Larson said, suggests multiple potentials, I'm having difficulty, I think some of us are having difficulty understanding why choosing either of those is a violation, given the nature of the jurisprudence around Fourth Amendment knock and talk.
And so I'm going to come back to this ordinary citizen standard because that is what needs to be applied. Would an ordinary citizen...
Stop. If these officers saying, I can't determine which of two these is the primary entrance, unless you've got testimony saying, no one could have that view, there is only one obvious door, I don't know how we get to the conclusion that an ordinary citizen's view of this is different from what the officer's view is.
That's what I'm struggling with.
If there... I think the factual problem that is not being put into this hypothetical is that it wasn't that they couldn't decide between two doors. Now, they did decide. They went to the middle door. That's where they went. And when I expect a visitor to come to my house, I don't expect them to knock on one door, not get an answer, and then, as the officers testified, continually attempt to make contact with the homeowners. That's not what ordinary citizen contact is.
Well, unless there are two, so look, you pull up to my house, I live in an old farmhouse. Nobody goes to what was the front door in 1855. It's too close to the road. You drive up to my house, there are two doors on the side. Should I choose A? Should I choose B? I'm not quite sure. So now your position is, and that seems to be what the officers testified to, if they had chosen the back door first and knocked and they didn't get an answer, you'd say, well, they were fine to be there, but they have to go away now because they only get one shot. But then the search would be valid because there they were, they saw the black sheeting, they smelled the pot, all good. If that's right, that's weird.
Well, I don't think it is right, Your Honor.
Okay, so why not given this record?
Well, so there's two questions. The hypothetical, should I choose the back door first? Okay, my position is, if you are going to enter into a backyard, there needs to be some factual support for why you think that back door is the primary entrance. What does the record show? The record basically says we thought it was. There's really not a whole lot else. And so is there even facts to support their conclusion that they think it's the primary entrance? I would say no, there's not.
Okay.
The trial judge gets to make a determination whether they're being credible or not about that. Your child,
Yes.
You're now saying that was an incredible statement for them to make. Well, the judge didn't agree with you.
The trial judge agreed that the officer's intent was to look for the defendants, that they weren't engaged in some kind of subterfuge to secretly do a search while they're looking for the defendants. That's what the trial court found.
Did the trial court make any findings about whether there was a primary door or a door that you would expect an ordinary citizen to go to?
I don't believe so. I think that the trial court found the officers credible, found the officers' statements credible, and said they're not engaged in subterfuge.
Is it your view that it is a factual finding for the trial court to make which door is the primary door, or is that the legal question we're asked to decide?
Well, I think in this case, what I'm asking the court to decide is a legal question. Did the officers expand their implied license to approach a home by knocking at a door, getting no answer, walking into the back door?
But I understand. But you've conceded, and I think you have to, that not every house is created equal and not every door is created equal. And I can tell you I've been to Justice Larson's house and even been in a door with her, and I still don't know what the right door is.
You've been invited?
Yes. I didn't expand my license in any way. I just went, but I really don't know what, I promise you, her doors are really confusing. And I promise you, if you went there, you would say like, yeah, they could probably go to any door and they're fine. And they probably could go to like 2 or 3 because they're all like kind of next to each other. And
Well, if that's
So-
ordinary citizen conduct at that home,
But that's the point.
that's the question right here. If the trial court didn't make any findings, about whether the back door versus the side door was the primary door or the door that any citizen would go to, what do we do with that?
if this court believes it's proper to remand and build a factual record, we'll certainly take that. But what our position is, the officers instinctively knew the correct door to knock at because they did it twice. They approached the house on 2 different occasions, a house in 2 completely different settings. One's vacant, one there's people at home, and they go to the same door. I understand crafting a rule for everyone to follow is a little bit more difficult. These officers didn't have a problem following my rule at all. They followed it perfectly without
Can I
knowing.
ask you a similar question to one I asked in the first case concerning what rule of law you would like to see emerging here? You variously, I have two sub-questions there. One, you variously use the term stranger, visitors, uninvited visitors, public, citizens, ordinary citizens. What exactly should be the standard? By what prism do we assess the police officer coming to the door? By which of those standards, and what is the source for your standard? Question number 1. Question number 2, are you asking that a rule emerges from this case, and I'm not saying you're right or wrong in doing so, but are you asking that a rule emerge from this case that no matter how much hubbub can be heard in the backyard, no matter how accessible it is, no matter what other circumstances might suggest that the person whom you're looking for is not in the house and cannot answer the front door, but can easily be contacted if you walk several yards into the backyard, that the police are never entitled to enter somebody's backyard if they first knocked at the front door and received no response? Is that the rule that you believe ought to emerge from this case? You never can do that under any circumstances. So I've got 2 questions. What is the standard that we're likening the police officer to? And is that the absolute black and white rule that you can't go to the back door that you would like to see emerge from our opinion?
Ordinary citizen standard,
Where do you get that from?
that comes from Hardinas and from the Michigan Court of Appeals have been applying that standard for 15
So
years.
not uninvited visitor.
I would argue there's really not a difference.
Well, there may be nuances of difference, and we need to respect the fact that in the 500 cases we might hear over the next 50 years, some of those nuances will come to have some impact.
Yeah, I think ordinary citizen to me means, if you're invited, that to me that means different than just an ordinary citizen. I mean, I would say ordinary citizen is the kind of broadest standard that applies to someone who's not a special class invitee.
The language from Hardines is any private citizen, any, which I tried to figure out what that means, and any private citizen, probably doesn't mean some private citizens. Like, I might expect my mom to go to the back door when she knocked and I didn't answer, but she thought I was there. But I might not expect my neighbor to do that, right? So the question is, what does any private citizen mean?
And that's where I guess I'd fall back to ordinary kind of fits that gap.
Or might it mean all? Does it mean like my mom and, if both my mom and the neighbor and the police officer would be likely to go to the other door, which they might at Justice Larson's house, I'm telling you. Any person in the category might go to all the doors.
Maybe one day I'll find out.
Probably not. Probably not.
Yeah, I mean, to me, ordinary encompasses is the rule that has to be applied because it's the most broad term. I mean, if you're talking about invitees, I think to me that's a different class of people. Can you ever go in the backyard? No, I'm not proposing a rule that you can never go in a backyard. Now, what
rule are you proposing then?
The rule we're proposing is officers are, during a knock and talk, officers are entitled to approach the door, most likely, that an ordinary citizen would approach, knock, absent invitation to
And
stay.
having been unsuccessful in that respect, what options remain, if any? Can they go to the back door? Under any circumstances, I'm asking you.
Of course, ruling out exigent circumstances, and they don't have a warrant, no.
Well, we know they don't have a warrant, but what are sufficiently exigent circumstances if they hear noise and hubbub and people playing in the backyard and people sitting and conversing in the backyard? Is that ever a warrant for saying, well, let me walk back there and just let them know that I'm here?
Absolutely not. Being home is not an invitation for anyone to come into my yard.
Let me just test your theory. At Justice Larson's house that I have not been invited to, apparently it's hard to know what door to go to. So is your rule that if you guess wrong, you get one knock if you're the cop, even though you say, well, maybe I hit the wrong door? One knock. You get to make your choice, and if you guess wrong, that's it.
Under the vast majority of circumstances, yes. An ordinary citizen would pick a door.
But that's right. There's no magic door. You go to Justice Larson's house. You take your best choice. You don't get a response to say, I probably guessed wrong. It's probably the other door.
When we're talking about the Fourth Amendment, the protection of the home, and the unique place that a knock and talk has with, the PR person behind coining the term knock and talk deserves an award. This is an investigation. The police are there to investigate. And
Stop. I understand the rap. I'm just really trying to figure out if it's genuinely hard to tell which door. Is your rule if you're a cop, you only get to knock on one?
The baseline of my rule is you get one door. Yes,
Okay,
that is the
I just
rule.
wanted to understand your position. Thank you.
Is that what any private citizen would do? I mean, if the rule is any private citizen and it's a very large piece of property with a barn in the back, is it unreasonable to say any private citizen would knock on a door and then upon discovering that no one's there, take a look in the backyard where there's a huge barn to see if the person you want to talk to might be there?
Fourth Amendment, inherently fact-intensive, very difficult to apply bright line rules in this area.
What we've been told is any private citizen.
Right, and I guess what I'm saying is there theoretically exceptions where, hey, what if there's two doors right next to each other? Can I knock on one and not knock on the other one? That'd be absurd for me to say that's unconstitutional. Are there and I would say one door, after that it falls back to ordinary citizen standard.
Do you never get to the barn in the backyard? If, the facts of this case, tying all these questions together, there's cars in the driveway, the barn doors are open, there's some tools out on the table, very much making it look like someone is there. Does the person there not expect a public visitor ever to approach the barn? If, I've knocked on thousands of doors as a political candidate and canvasser. And
no one answered.
That's right. Ever.
So I always would go to the backyard. I'd be on the couch watching the Lions game. I'd violate the curtilage all the time. That's a different story. But I'm thinking of Hoosiers. Coach Norman Dale shows up at the farm and people are in the back, and so of course you proceed to the back even though you're an uninvited guest, just like Justice Zara said, to approach the people who are there. Are you saying that's a gross violation of social custom for someone to do that?
Well, of course, if we're talking about curtilage, if the barn is not in the curtilage, then that's a different story. If we're talking about curtilage, then, an officer coming up to one door, knocking, not getting the answer he wants, simply being home is not an invitation for someone to come into your backyard. If I don't want to answer the door, I don't have to. That doesn't mean I need to ward off people from walking into my backyard. And that's our position, that when the knock and talk holds such a unique spot in Fourth Amendment protections of the castle, the Fourth Amendment requires that limitations be put on this investigation at a suspect's front door that's commonly referred to as a knock and talk. Thank you.
Good morning. May it please the court. I'm Catherine Dalzell, Assistant Solicitor General, here on behalf of the people of the state of Michigan. At council table with me are Aaron Lindstrom, Solicitor General, and Tim Boffman from Wayne County, here on behalf of Amicus, the Prosecuting Attorneys Association of Michigan. As this court knows, this is a case out of St. Joseph County about
Are
the
you splitting
scope
your
of...
time?
Pardon me?
Are you splitting your time?
Yes, I apologize.
You manage
Mr.
that
Baughman will be
yourself.
taking
Thank
10
you.
minutes of my time, and I know to manage my
You
own
manage
time.
yourself.
Thank you. This is a case out of St. Joseph County about the scope of a proper knock and talk under the Supreme Court's decision, Florida versus Jardines. And I think the easiest way for this court to resolve this case is to simply find that there was no trespass here and the police did not exceed what an ordinary visitor would do. As the court noted, there's no testimony from Radandt at the suppression hearing disputing that the back door was a common entrance. The police testified that they thought it was a customary entrance. They thought that it was either the main door or it could even be the primary door. They simply weren't sure. The trial court, as the court noted, found the officers honest and credible. It found that this was not a subterfuge for an illegal search. It found that the officers were genuinely trying to make contact with the people consistent with a knock and talk. And furthermore, it was reasonable for the police to think that the back door was an entrance that visitors might approach because there was a well-worn path leading to it. It was visible from the driveway. It was obvious that someone was home. As the court noted, the barn door was open. There was a dog running around. There was a light on. And there were tools laid out in the grass. So it was certainly reasonable for the police to think that this was a customary entrance here. And to step back a little bit, I think it's helpful to frame this case by thinking about this court's decision in People versus Howes. And in Howes, this court held that even a technical trespass does not transform an otherwise reasonable police action into an unreasonable search. That was both stated directly in a concurring opinion in that case, that the concurring justices said that even if there were a technical trespass here, we would still find it reasonable and not a Fourth Amendment search. And the majority opinion went even farther and rejected even the concept that property rights analysis or a technical trespass could make it unlawful or affect the analysis. With that in mind, I think that Jardines can be interpreted in one of two ways. One, this court can read it as holding that no technical trespasses are permitted. It adopts an ordinary visitor standard. And in that case, Howes would be abrogated, along with similar decisions. For example, we cited in our brief the Sixth Circuit decision Hardesty, where the Sixth Circuit clearly held that police doing knock and talks are permitted to go to the back door when they're not getting an answer at the front door if they think that someone's home. And of course, the Sixth Circuit cited 4 other circuits in making that ruling. And in fact, that principle was so prevalent in the case law at the time of the knock and talk here that it was in the Lefebvre Search and Seizure Treatise, which I think cited 14 Federal Circuit and State Supreme Court cases for that principle. So if Jardines is read that way as implying a property rights analysis, a trespass analysis, and an ordinary visitor standard for determining what the scope of the implied license is, to the extent that Howes and Hardesty and the other cases are inconsistent with that, they're abrogated. The second way that this court could interpret Jardines is, as the amicus Pam will argue, which is that a technical trespass could still be allowed under certain circumstances as long as the police are not acting with an improper purpose. And in that case, Howes would still be good law, Hardesty would still be good law, and there would be no problem here with the police action. So with that background in mind, I think there are 3 possible ways that this court can decide this case. The first, again, as I said, is just to decide simply that there was no trespass here. The police acted consistently with ordinary visitor behavior, and so on any reading of Jardines, there was no Fourth Amendment violation. Second, if this court agrees with the interpretation of Jardines that a technical trespass could still be permitted in some circumstances, meaning that Howes is still good law, then the police action here would certainly be permissible under that test. And third, if this court adopts the first interpretation of Jardines and holds that a technical trespass is not allowed, and if the court thinks there was a trespass here, then Mr. Radandt's conviction should still be upheld under the good faith exception to the exclusionary rule, because Jardines would affect then a change in law from Howes, Hardesty, and all of the other cases.
But counsel, let's make sure that we understand that knock and talk, and according to brother counsel, this investigation, this occurs when the police don't have enough evidence for a warrant, correct?
Not necessarily. It occurs whenever they want to try and speak with a subject to either they could ask
In the
consent.
instant case, there was not enough evidence to have a warrant to go.
That's correct.
That's correct,
Yes.
right?
Yes.
So the question I have is, as we try to establish a rule, based on the three elements that you presented, if you're looking at it from the standpoint of an ordinary citizen, and again, I just want to try to really understand your argument, and then the court can have a really good discussion about it.
Yes.
Under your perspective, to argue that there's no trespass and that this was done in the correspondence with what an ordinary visitor would do, is it in fact the state's position that an ordinary visitor could come to my home? Let's just say I live on a street in Birmingham. They could come to my home. They could go to my front door. If there's no answer, they could go to my back door. They could look in my windows, and they could remain on the premises until I actually come and speak to them. Is that ultimately the state's position in this argument?
That's not the state's position, and I don't think that this court needs to decide that question, because the relevant question here is whether the police violated the knock and talk or exceeded
But I'm
the scope.
focused on the jurisprudential significance of this.
Correct.
Because you gave us three options here. So this affects every homeowner in the state of Michigan. What I'm trying to understand in this situation, as a homeowner, what would your perspective be as it pertains to my right of privacy to be in my home? You don't have a warrant, you come to my home. Let's just say, I'm trying to get a bright line rule because the chief is focused on jurisprudential significance. You have a situation where most homes, you have a clear front yard, you have a clear backyard, you have a street, you have a sidewalk, you have all these things. Would it be your position that the government has the right to go and walk around my home, look in my windows, and knock on all my doors, and remain there until I actually come and talk to them?
No.
That would not be your position, correct?
No, that would not be our position. Our position is, my interpretation and our interpretation of Jardines is that police would be limited to ordinary visitor conduct. And here, this was ordinary visitor conduct, and there are a lot of reasons for that, but I would boil them down to three main reasons. First, the back door in this case was visible from the driveway. We have to remember the layout of Radandt's property, which is that the driveway went directly to the side door. The back door was visible from the driveway. There was a well-worn path leading to the back door. And again, the third thing I would point out is that it was obvious that someone was home here. And the police indeed testified that they thought someone was home. They thought that their knocks were not being heard. And so they
But go to Justice McCormick's comment, which is there are people she doesn't want to talk to. And isn't that your right if someone's not there? And if you could answer, if someone is at the home, do they have to come and speak to you before you leave as a government official?
No, and it's not the state's position that the police can engage in endless knocks. The police can't sit there for 45 minutes and continue.
Is it your view that the implied license expands if the police have reason to believe someone's home? Or was that just, is that part of the Court of Appeals opinion maybe a glitch that you don't need to win this case?
I don't believe that we need to win that, or need that to win this case, but I do believe if you're thinking about an ordinary visitor, I do believe that if there are signs that someone is home and you're not sure which is the primary door and it seems like the person is not hearing you, I do think an ordinary visitor would do what the police here did.
But it's a little bit inconsistent with, one of the things that Jardines says is the normal implied license that the police have is to go to the front door, knock, and if nobody answers, to leave. Like that's normally what you're told is what the police can do. So if this was a case where there was a clear front door, no one's talked about this yet, but when I look at the photos in the exhibits, there's no clear front door, which makes the question of what the main door is even more complicated, I think. But if it was a case where there was a clear front door and there was no answer, but the police really believed there was someone in there because they could hear noises, do you believe that would be a reason for them to go to a clearly not main door?
I don't believe they could go to a door that a visitor could not be expected to go to.
So the fact that they believe someone's home doesn't change the calculation. You're saying it
Right.
might be relevant in a case where it's not clear what the main door is. I
Right.
just want to
Yes,
sort
yes,
of
and thank you.
parse what you were
Right. Our position is that if it looks like someone's home, that doesn't give police license to do, I think, what an ordinary visitor would not do. I just
Right.
think that's a relevant circumstance as to what an ordinary visitor might be expected to do in the case. And particularly on the facts of this case where, again, I mean, the trial court held that the front door, or found as a matter of fact, that the front door was not an entrance that visitors would use. So this is not a situation where the police bypassed the main door. It found the officers credible. It found that their purpose was not a subterfuge for a search. They were really trying to make contact with the residents. There was a lot of testimony to the effect that the police believed the residents weren't hearing them. So this is not a case where the police are just standing there knocking for 30 minutes because, you know, they know that the people aren't answering deliberately. They just thought that they weren't being heard. And indeed, when the police followed the path to the back door, they heard talking and laughter and music, which is, again, more corroboration that the residents were just not hearing them. So those are all reasons that the police, their belief that this was an entrance that a visitor would use was reasonable. And again, I would emphasize that Radandt put no contrary facts on the record, and the trial court at least strongly implicitly found that the back door was a customary entrance here. The trial court contrasted the Court of Appeals' decision in People v. Galloway by saying, you know, the problem in Galloway is that the police didn't follow a path that was open to the public, but here the police followed a path. The court also noted in Galloway the problem there was that they didn't follow a path, quote, as someone would go to visit the home, end quote. But here the trial court contrasted that and said, but that's exactly what the deputies here described.
Well, I guess I'd have to follow through on the Chief Justice's question about the jurisprudential significance of this case. If your characterization of this case is merely that it's a no clear front door case, I was kind of interested in knowing what the general rule was when you had a clear front door case and you went to the back door. Are there circumstances, that was what I was trying to, elicit from opposing counsel. Is it your view you can always go to the back door? Is it your view you can never go to the back door? Is it your view there are exigent circumstances or there are ordinary circumstances where you can do that? If the only question in this case is what you can do in an unclear front door case, it doesn't seem to me like there's going to be a lot of those cases coming down over time.
I would answer that in 2 or 3 ways. My first answer would be that I do think that as a jurisprudential matter, I don't detect a lot of disagreement over the legal standard between the parties here. So in that sense, I think there's just no disagreement.
This is an application case?
This is an application case, yes. And it was Mr. Radandt who lost below and brought the application for this court to hear the case. And I think that to answer your question, the standard that Jardine sets forth is an ordinary visitor standard. This question is the scope of the implied license for an ordinary visitor, and the court said that it is implied from the habits of the country. You have to look at a number of things. For example, what would be typical for a visitor, what might cause alarm to the resident, what would be expected from a reasonably respectful citizen. I don't think this court can draw a bright line rule.
Well, that's right. I mean, doesn't that mean the answer to our dilemma, the opinion that we should write if we write anything, the standards we ought to apply, are exactly those that emerge from the Fourth Amendment? Is it reasonable under the circumstances for the police to do what they've done? That's it.
Correct.
Is it reasonable or is it unreasonable? If it's unreasonable, it's a violation of the Constitution. If it's reasonable, it's not. It's that simple, except it's infinitely difficult to determine in every individual case whether something falls on this side of the line or that side of the line.
Correct. I think that would be a good approach for this court to take. And the touchstone of the Fourth Amendment is, in fact, reasonableness. And and especially on the facts here, as we mentioned in our brief, I think any ruling for Radandt on the question of whether there was a Fourth Amendment violation would inevitably result in bright line rules that this court doesn't want.
But to say that it's difficult to have bright line rules doesn't mean that it's difficult or impossible or inappropriate to have general rules, default rules, presumed rules, and I'm not clear from either side, what those ought to be here.
That's correct. And I just, again, would adopt the baseline of Jardines, which is we ask what an ordinary visitor could do. That's, of course, very vague, but you can come to certain principles from that. For example, in this case, again, the police followed a well-worn path to the back door. It looked like someone was home. And the back door is visible from the driveway, which is a place where visitors have a right to be. It's not like it was some door that you never would have seen unless you trespassed. So in a case like that, those are standards that guide police behavior. But I don't think that we can have the sort of standards that Radandt is advocating, which is that you only get to knock once because, as Justice Larson pointed out, what would the police do at her house? It can't be a one-strike rule where you get one knock, and if you guess wrong, you're just wrong. There can't be a rule that there's only one door. There can't be a rule that you can never proceed to another door if you think the residents aren't hearing you. And again, the case law is abundant on that point, and I don't think that Jardines
What impact,
disturbs
if we're
that.
being fact-specific, what impact does the fact that they weren't dressed in uniform when they came to do the knock and talk have?
I'm sorry, pardon me?
The uniform requirement. What impact the fact that the officers were not in uniform when they came to visit? Does it have any?
I don't believe that has an impact. I haven't thought about it from that perspective. I think that, again, police are limited to what an ordinary visitor could do, and if an ordinary visitor could knock on Radandt's door and ask questions, I believe that the police would introduce themselves as police officers. So I don't think that that would change the analysis here.
And if we were to draw a right-line rule, even though I understand your argument, but I'm looking at this in a more general perspective, would you, from a state's position, would knock and talks be limited to specific hours, or could you do a knock and talk under this reasonable standard? Would it be the same time period that would be allowed for salespeople or political candidates?
I think it would depend. The Supreme Court, I don't think, set forth any determinative factors. They did indicate that time of day could be relevant to the consideration. I don't think that that would be a determinative factor. For example, the police might knock on someone's door who they know works night shifts, if it's an emergency room nurse, for example. And in that case, it might not be odd for the police to do that. Or if it's someone who works in a profession who would be expected to know the police officers, or not necessarily the police officers,
that becomes kind of general, doesn't it? Where basically, so the police could come to visit your house without a warrant and do a knock and talk. What you're saying under this perspective is it would be interpreted case by case, but technically the police could come, or the government could come to your home at any time without a warrant to conduct a conversation with you, and they could come deliberately at night if they wanted to.
I would say that I do think it would be very rare that it would be.
But rare is one thing. As a court, we have to figure out what the law is going to be. So under your argument, it could be allowed for.
I think that the standard would be ordinary citizen behavior, and that's the standard that the Supreme Court set in Jardines. And I do think that time of day is relevant. I think it's even highly relevant. I think it would be very rare to have a case where the police show up at your door in the middle of the night, and that's going to be considered consistent with ordinary visitor behavior. In rare cases, it may be under the circumstances, but I think that in terms of the guidance this court puts forward, I think that the ordinary visitor standard is adequate. And I would just, if the court will allow, cede the rest of my time to the amicus Pam. Thank you.
Good morning, Your Honors. Tim Boffman, representing the Prosecuting Attorneys Association of Michigan as amicus curiae in this case. No trespass occurred in this case, but more importantly, no search occurred in this case because it is the latter that is protected against when it is unreasonable. The Fourth Amendment protects the right of the people to be secure in their homes against unreasonable searches. The Fourth Amendment does not protect right of the people to be secure in their homes against government trespass. The two terms are distinct, and the distinction was well known to the founding generation. More importantly, Jardines and Jones make clear that not all government trespasses constitute searches. When counsel for the defendant says the trial judge found, and doesn't quarrel with this, that the purpose of the entry into the backyard was to talk to somebody who in the premises, that ends this case because it means there was not a search. Jones says, and I quote, "A trespass on houses or effects or a cat's invasion of privacy is not alone a search." So a trespass onto the curtilage is not alone a search unless it is done to obtain information, and flipping it, the obtaining of information is not alone a search unless achieved by a trespass. As Jones also says, trespass alone does not qualify as a Fourth Amendment search. There must be conjoined, this is again quoting from Jones, there must be conjoined with trespass, and we again submit there was none here, but there must be conjoined with trespass an attempt to find something or to obtain information.
Okay, but, are you still in your free fire zone? I'm sorry.
I don't think I have one.
Oh, okay, good. But it can't be the case that simply because the purpose was to talk to people that the police can go wherever they want, right? So let's say they came to the obvious front door, they knock on the obvious front door, nobody answers, but the door, let's say the wood door, the steel door is closed and it's just a screen door. They can hear people inside, so they open the screen door and they go into the living room because they just want to talk to the people. Come on. They can't do that, right?
Well, if they do that, they have trespassed.
Well, they've trespassed, but you said trespass doesn't violate the Fourth Amendment.
It does.
So they still haven't violated the Fourth Amendment, even if they walk into the living room.
I don't say it,
They
Jones.
walk back to the kitchen.
Jones
They hear
says it.
voices in the kitchen.
Jones and Jardines say it. I don't say it. They say you must have conjoined, specifically, an attempt to find something or to obtain information, the circumstances you're positing, I
So
think,
as
would
long
give...
as all they want to do is talk, they can hear me up in my bathroom, I'm taking a shower, and they're like, hey, I just want to talk to her, the water's on.
It's knock and walk.
Really?
Again, I read from the case. You have an unlicensed entry, but unless it is for the purpose of obtaining information, it is not a search. It says it repeatedly. You have to have both. In the circumstance you're on positive, I think...
So your position is I sue them for trespass.
Pardon?
I sue them for trespass, but I have no Fourth Amendment expectation
Yes,
of privacy.
that the Fourth Amendment...
The water's on, they want to talk to me, I'm obviously in the shower. They can just come on in.
The law may preclude that, but the question is whether it's the Fourth Amendment. As Justice Scalia pointed out in his Carter concurrence and in Kylo, there's lots of things that we would like to be protected in terms of laws of privacy, and we have HIPAA and FERPA and the Omnibus Wiretap Act and things like that. So to protect against privacy, but that doesn't mean they're in the Fourth Amendment, no matter how outrageous it might be if government's violated privacy in a particular circumstance. So the question is, as the court said in Jones, in Jardines, in Kylo even, where they basically posited a virtual trespass. If you obtain information from the interior of the home by a sense-enhancing device that you could not obtain otherwise than making the trespass physically, then that is a search. But again, it's the purpose of using the sense-enhancing device is to obtain information about the home. You can have outrageous circumstances, and you can prohibit those. But if we're talking about the Fourth Amendment, the court, it seems to me, rather clearly says, I'm quoting, trespass alone does not qualify as a Fourth Amendment search. It must be conjoined with an attempt to find something or to obtain information. Now, in this case, we just have walking around the back in order to inquire at the back door, and counsel overreads what obtain information means, and I think it causes some confusion because it's a little confusing from the opinions.
Well, what happens, given that theory, the officer walks in unbidden to talk to Justice Larson in her shower and sees her marijuana grow operation right there in the living room.
I hide it better.
Under Jardines and Jones, if what you conclude as a finder of fact that purpose of the trespass was not to obtain information, no matter how outrageous it was, is it a little trespass or a big trespass, it is not a Fourth Amendment search, although there may be.
What they see in plain sight, once they're unbidden, is.
That's what the cases would say.
Okay.
Now, this court.
The Chief Justice cut you off when you were going to give us the limited scope of obtaining information.
Yeah, the obtaining information, the defendant says essentially that anytime the police go up to the door and knock to talk, they are there to investigate, they are there to obtain information. And that is, as he puts it, physically occupying the curtilage of the home for the purpose of obtaining information, and that's a search, which means the police could never go up to the door or around to the back unless it was purposeless or aimless. And that's not the case, and Jardines dispels that notion because it says that it is not a Fourth Amendment search to approach the home in order to speak to an occupant. The mere purpose of discovering information in the course of engaging in the conversation does not cause it to be a Fourth Amendment search. What you have to be doing, if you look at Jardines and Jones in their context, to be a search, obtaining information doesn't mean from people on the premises who are willing to talk to you or even consent to a search. It means about the premises, about something on the curtilage, something in the premises. That's what obtaining information means. Not, I'm going to talk to you and you may tell me something.
Physical evidence, not discourse.
Pardon?
Physical evidence, not discourse.
Ordinarily, it would be physical evidence. And the court does, it kind of uses obtain information and find evidence interchangeably in the Jardines opinion. Now, we don't believe there was a trespass here, and I think the court can resolve this case on the issue is, was there a trespass under Jardines? And the court has asked for a rule. I don't think Jardines and Jones changed the law that has existed up until this time, and that law is spelled out very well in the Hardesty case. Hardesty says that if the police wishing to make an investigation, and I think we need to keep in mind investigations can be of all kinds. This kind is to see, you've got a call that somebody's selling marijuana out of here and there's cars coming and going. It could be there's a break-in next door and we want to do a canvass and say, did you see anything? There's all kinds of reasons to knock on the door. And the court in Hardesty says the rule that they adopt, and I think the court would do well to follow, is that we're knocking at the front door is unsuccessful when the police are there to make inquiry.
But that's not what happened in this case, though, correct?
Pardon?
I mean, that's not really what happened in this case. This was the fact that a warrant wasn't obtainable. So this happened in lieu of a warrant. So I guess my question would be if you could help me to understand, the parameters of knock and talk, which is what the state is seeking. Does this not really, for all intents and purposes, go against the warrant requirement? I mean, is this going to be in lieu of getting a warrant?
Well, it's absolutely in a circumstance where the police may not have information to get a warrant. It may be a circumstance where they're not investigating criminality as to the inhabitants at all. As I said, it may be wanting to know, did you see anything because there was a break-in next door, and we're investigating that, and we want to talk to people in the neighborhood.
But is knock and talk going to be expanded to such a definitional ability that it's going to make the warrant requirement somewhat irrelevant or somewhat unnecessary?
Well, it is unnecessary unless there is a search. And inquiring at the front door, or as I'm going to say, at the back door, knocking on the door to ask questions, even to seek a consent to search, is not a search. Jardine says that directly. That's not a search. And the rule from Hardesty and from this court's...
The result is the same, though, is it not?
Pardon?
The result is the same. The impact on the defendant is the same.
No, I mean, he can say, no, go away. And you can't come in my house. And they'd have to go get a warrant. So you're still protected by the warrant. They can't come in. It's all up to me.
But then with Justice Larson's, you've indicated that they can go in.
Well, if their purpose is to inquire and they do something horrendous, I guess you could deal with that in some other context, but it's not a search. It is a trespass. I'm not denying that it's a trespass if they do that. What I'm dealing with here, and I think what our facts are dealing with here, is they're there to make inquiry. They're not there to obtain information regarding the premises. The judge found that. Counsel seems to have conceded the judge found that, and that was within the judge's parameters, found that they were trying to find the people on the premises. And again, what Hardesty says is that when knocking on the front door is unsuccessful, in spite of indications that someone is at home, and I think this is the rule that I would advocate, just follow Hardesty, an officer can take reasonable steps to speak with the person being sought out, even if that requires some intrusion into the curtilage. That wouldn't allow, I think, reasonable steps, peeking in the windows. It would allow going to the back door, as happened in Hardesty, and checking. Otherwise, this court's opinion in People v. Howes would have to be overruled. The defendant can't win unless you overrule Howes. Howes is an inquiry into an unattached garage at the rear of the premises. Now, they started from the rear, but if you accept defendant's premise, the police would have had to come to the front, because the defendant has said even if you believe the people that are in the backyard and have reason to believe they're there, you can't go in the backyard. So they would have had to come to the front, make a futile knock on the front door, though they had reason to believe people were in the garage because they heard the noise of people and tools being used, and leave. They were in the alley, they came in the backyard through the gate, and they walked up to the door of the garage to make inquiry of the people in the garage, because that's where it was reasonable to believe they were. And this court, citing Professor Lefebvre, upheld that entry. And my view would be, if in this case, when the police had approached, assuming the pole barn is on the curtilage, they had reason to believe the people were in the pole barn, they could have walked up to the pole barn. Unattached garages, carports, attached garages, and the like. If it's reasonable, in order to make inquiry with the people on the premises, when you're unsuccessful at the door, you may make those limited incursions. That's within the license. I do believe that is within the license.
Thank you.
Oh, I'm sorry. Thank you very much.